state all-purpose calendar with the State Court of Fulton County. This is a list of misdemeanor criminal cases in which individuals were recently arrested.
Yeah.
Excuse me.
What?
Sorry.
Hold on, sorry.
ACDC, may we mute the screen? Or with the host mute ACDC, please? Thank you. All right, as I was saying, this is the state all-purpose calendars with the Fulton County State Court, and that's for today, October 19th, 2023 at 9 a.m. These are cases in which individuals had been arrested and charged with certain misdemeanor offenses, and bonds have been set on these cases. Today, we are going to address the status of the case, including whether a plea is going to move forward or whether the cases are going to be arraigned and further notice for trial. Other matters that we may address are bond modifications and so forth. If you are a defendant charged with one or more misdemeanor offenses, please remember that you have a right to remain silent. Anything that you say about the facts of your case, your statements can and will be used against you. You have a right to an attorney. If you cannot afford one, we will appoint an attorney from the conflict defense list or the public defender's office to represent you. All right, Mr. Howard. All right, let me see. Did we get the public defender's announcements yet?
Should have Judge send it, Ms. Champion,
Okay,
as well as everyone else.
maybe I probably got it.
Yes, Judge, I forwarded them to you.
Okay, there it.
Good morning, Judge Law.
Good morning, Deputy Francois. How are you?
Good, thank you. Ms. Milton had asked to go first at ACDC, but I'm not sure.
Well, she don't need a second. Mike's got to talk.
Okay. All right, so we're gonna start here in courtroom 2. It's gonna be on the probation calendar, positions 3 and 4, Mr. Hudson.
Okay, that was the probation calendar, position 3 and 4. Is that correct?
That's not.
Oh, I'm sorry.
Was that position 3 and 4 on the probation calendar?
Yes, Judge, thank you.
Okay, thank you. All right, this is the probation revocation calendar, and we are addressing Damian Hudson. Mr. Hudson is positions 3 and 4. And so let me go ahead and reference the cases. Mr. Hudson, first of all, I'd like to remind you that you've been advised of your right to remain silent, and your attorney was going to be Mr. Derek Howard with respect to this proceeding. This is a probation revocation in which pursuant to a conviction, you were placed on probation, and there's now an intent to revoke your probation and have you serve out the remainder of the time in prison. In your particular case, it will be 22 CR 004963J, in which the charges were criminal trespass causing damage to property and battery causing substantial physical harm. The second case on the calendar is Mr. Hudson's revocation case number, and that's 23 PV 1336. Our probation officer, Officer Allison, good morning.
Good morning.
Officer, may I place you on oath, please?
Yes.
Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes.
Thank you. And what is the state's position with regards to Mr. Hudson?
Mr. Hudson failed to obtain the law by committing a new offense of financial transaction card theft by receiving stolen property, financial transaction card fraud on August 11, 2023 in Fulton County. He failed to report to the office on November 22nd, 2022, November 29th, 2022, and December 13th, 2022. Did not complete 12 weeks of anger management and did not complete drug and alcohol evaluation. He has 280 days left remaining on his case. Probation is recommended to continue on probation and enroll in the evaluation within 30 days upon release.
All right. And does he still have any holes at the jail?
He does have a Superior Court matter. He has bonds on those, Judge. So obviously we just asked the court to follow that recommendation, and whenever he's released pursuant to that case, that he's indicated he will comply with the conditions of probation.
Do we have a good address on Mr. Hudson?
Yes, we do, Judge.
Miss Allison, do you have a good address?
I don't think that was the issue, but
Officer Allison, do you have Mr. Hudson's new address or good address?
I have a current address of what we have. If it hasn't changed since he signed up for probation, then yes.
What's the street address?
I can look it up for you.
If he has changed his address, we will need to
I
know.
have 58. Sorry. It's hard to read. Christopher Lane.
okay, yeah, it should be 5667 Dealwood Crescent Lane.
Okay, so I do not have that address. If you can email it to me or put it in my chat, please, and I'll
Yes.
update it.
All right, Mr. Howard, please provide the updated address to Officer Allen.
Okay. I'll put that-
And with regards to the probation matter, this will be recorded as a probation violation in this particular case. Within 48 hours of being released from the Fulton County Jail, upon making bond in any other cases that he has, Mr. Hudson must report to his probation officer at the probation office at 132 Mitchell Street in downtown Atlanta. He will resume his probation, and he still has 280 days to complete in this case. Within 60 days of being released from jail, he must enroll in a qualified anger management program and complete his 12 weeks of anger management classes. And also within 60 days of being released, he must enroll and complete an alcohol and drug evaluation and submit himself to any treatment if required. Failure to report upon being released from jail will result in another revocation and immediate arrest and a complete revocation of the probation in this case. Thank you.
Thank you, Judge.
Probation, number 7 and 8, Mr. Thompson.
All right, I have Mr. Thompson at the South Annex or 3 South. Which one is it?
3 South.
3 South, okay. And Mr. Howard, are you, or Mr. McLean, are you representing Mr. Thompson?
I do.
All right, good morning, sir.
Good morning.
All right, we have Mr. Michael Thompson at the 3 South location. And Mr. Thompson, my name is Judge Law. Please remember that you have a right to remain silent. Anything that you say in open court, your statements can and will be used against you. You have a right to an attorney, and representing you is going to be Mr. Michael McLean. This is going to be a probation revocation matter with regards to your case 23 CR 000067A, in which you were convicted of battery family violence. Your probation revocation matter is referenced as 23 PV 1232. Officer Allison, excuse me, you're still under oath. What's the reason for the revocation of this case?
The defendant failed to report on July 6, 2023, July 10th, 2023, July 11th, 2023, and July 27th of 2023. He did not complete 4 weeks of anger management. He did not appear for a prior revocational hearing that was on June 13th of 2023. He has 141 days left remaining on his case. Probation is recommending to revoke the remaining balance.
And serve the rest of the time at the jail?
Yes.
All right. which means he would have, what, 70 more days? 70, 71 more days left?
Monday, Tuesday.
All right,
Um,
if we. All right. Mr. McLean?
just about, yeah.
Your Honor, he did appear at the June 13th revocation hearing. It was an in-person hearing with Judge Roth and I suppose in their courtroom at the courthouse. The other dates, I cannot deny that he missed some dates, but they are sounding like they're 3 or 4 dates within July. And so I imagine those are reset dates. Usually a person on probation will be reporting about once a month rather than once a week or once every 2 weeks. So they sound, I'm just making the point that they sound a little worse than it is. Your Honor, at the time it was June 13th, at the time of his June 13th revocation hearing, the FIP was converted to the 4 anger management, and he misunderstood the wording of the judge at the time. He was saying, well, you know, to have to do this 4 a.m., this 4 anger management, and basically he was saying, well, if you get it done quicker, and Your Honor, he was in a wheelchair at the time. He'd been injured. He was not in the best shape at the time of that hearing, and he misheard. He just flat out misunderstood. He thought it was optional. He sincerely thought that the 4 anger managements that he would be just obligated on other things instead of doing the 4 a.m. But if he did the 4 a.m., he would get things over with quicker. So he had a great misunderstanding, and that is unfortunate. He is throwing himself on the mercy of the court. He has 3 children under the age of 11, 2 boys and a girl. He does work warehouse jobs. And notice now he's gone from a wheelchair to using a crutch. And he needs to get back to working as soon as possible, Your Honor. He works in industrial things like on Fulton Industrial Boulevard. He's worked at a company that makes plastic bottles. He's worked at a company which packs up flowers and candies. I said, that sounds like you were working for a contractor that works for edible eats or treats or something like that. Your Honor, he's worked several months in the last couple of years, like 7 or 8 months each time that the temporary agency sends him to one of these factory or warehouse jobs. So he's quite industrious, and he would like another chance, Your Honor.
All right. Ms. Tyson, our pretrial officer, could you give me a history of any probation violations other than this one?
Let's see. This is Mr. Thompson.
Yes, Michael
One
Thompson.
moment.
And Judge, that was a mistake. It was supposed to be, I was supposed to say it was, he failed to comply with the orders for the prior revocation hearing on
Revocation.
June 13th. Yep.
Okay.
It looks like he had a probation, well, it was a felony probation violation back in 2009 and a violation of parole. Let's see. He had another one in 2010. FTA in 2011. Another probation violation in 2012. And it looks like these are all the Douglas County also. See if there's any more recent ones.
Okay, thank you. Anything else, Mr. McLean?
Nothing, Your Honor. Thank you.
All right. And he's been in custody now for 29 days?
I believe that is correct, yes. I've met him twice in the last 2 weeks, and each time he was on the crutch. So he's visually memorable as a client to me, as well as our conversations.
All right.
He is just simply, sincerely asking for a break.
I will accept that he's been in custody now for 29 days as a result of the violation. He had a probation revocation back in June. He was instructed on how to continue with his probation. He failed to comply. So this is a second probation violation in this particular case, which will be on his record. I will allow him to continue on probation. Miss Allison, he has to report to probation within 48 hours. So he has to report to probation on Monday. Mr. McLean, does he have any holds at the jail?
Let's see. I don't believe he has any holds. I believe this is the only thing.
Okay, he has to report. He must report to probation on Monday before 3 p.m. And that would be October 23rd, 2023. He must report on that day, and then after that, he must report every month. I don't have a plausible explanation of why he did not report in the entire month of July, but if he misses one more date, probation has the absolute right to revoke the remainder of the time and have it serve out the remainder of the time in jail.
Very good, Your Honor. I'll double check on that.
Well, let me finish. Within 30 days of being released from Fulton County Jail, he must show proof that he has enrolled in an anger management program and is to complete the 4 anger management classes as soon as possible. He has 141 days left on probation, and he must report every month for the remainder of the 141 days. If he gets arrested again, if he fails to report, or if he fails to enroll in the anger management classes, then he can choose, then he's made his choice and he'll serve out the rest of the time in prison or in jail. He has the other option of serving out the rest of the time in jail, and he would have 71 more days left to serve. What would he like to choose?
I believe he'd like, it's my understanding, I think he'd like to be continued, Your Honor, and report Monday.
All right, Free South, could you unmute? Mr. Thompson, you have the option of serving out the rest of the time in jail. You have 71 more days, or you can continue on probation, but one more mistake and you're back in jail. What would you like to do?
I would like to continue on probation.
Okay, you have to report to probation on Monday. Today is Thursday. You have to report to probation on Monday before 3 p.m. If you miss one more probation, you might as well just walk back to jail, because you'll be serving out the rest of the time. You have to enroll in the anger management program within 30 days of being released from jail. Do you have any questions about that? Are you confused about anything that I've said? All right, if you have no confusion, then you have 141 days left to serve on probation. Make sure you report and you start your classes. Thank you.
Thank you, Your Honor.
This will be, yeah, this will be recorded as a second violation in this case. South Annex, who do we have?
We got Jarvis Riley.
And is he on probation revocation or the regular calendar?
Probation revocation or regular, I'm not sure.
All right, let's see. McLean, is this a SAP case? Jarvis Riley.
Oh, is that Montgomery Riley or Riley Montgomery? That's Miss McLeod's case. I'm sorry, I was confused by the name. That is Miss McLeod's case. It's conflict.
All right, Miss Maureen McLeod, are you on the Zoom?
Good morning, Judge. She's in Judge Edie's courtroom. She says she will be joining us a little late this morning, but she will jump on.
South Annex, his attorney is at another proceeding, but she'll join on later. We can either rejoin later.
Okay, can I leave a number in the chat for her to call when it's time to?
Yes, if you can send the number to our FC State Court host /Melissa. Do you see it on the chat?
Yes,
All right, if you can leave a number to call.
thank you. I will.
All right, courtroom 2. Thank you, Sergeant Smith.
Thank you.
This is gonna be on the probation calendar, positions 1 and 2, Mr. Gibbs.
All right. And Miss Melissa, okay, thank you. Position 1 and 2. This is State versus D'Angelo Gibbs, case number 20, excuse me. The original case is 21 CR 0073201. Mr. Gibbs, a probation violation case reference number is 23 PV 1335. Mr. Gibbs, you've been advised of your right to remain silent, and your attorney is Mr. Howard. Officer Allison, yes, good morning. Yes, ma'am. We are on D'Angelo Sherrod Gibbs, positions 1 and 2. And his original, I am assuming the charges in which he was convicted was DUI, following too closely and improper passing of an emergency vehicle. Officer Allison, what's the basis for his revocation?
Mr. Gibbs failed to pay court fines and surcharges in a total of $1,012.50, probation fees in a total of $280, victim crime funds $63, failed to complete drug and alcohol evaluation, did not complete 40 hours of community service, failed to complete risk reduction course. He failed to appear to a prior revocation hearing on July 27, 2023, and did not complete victim impact panel. Mr. Gibbs have 28 days left remaining on his case. Probation is recommended for time served.
And how much time has he served in jail?
He's been in custody 7 days as of today, Judge. And he has a hold for another county.
All right.
We have court
Anything-
accept that recommendation.
Yes. All right. Yes, Mr. Howard, any response?
Judge, we'd ask the court to accept that recommendation.
He's only completed 7 days,
Yes, this.
and he's got 28 more days to serve out.
That's correct, Judge.
And let me correct, he was convicted of DUI under the influence of alcohol, less safe. He pled guilty.
Yes.
And he has not completed any of the requirements for his sentence for DUI.
No, he has not.
And you want me to commute this to time served for 7 days?
That's correct, Judge. And the only thing that we believe he was able to do or has done is the community service, but obviously don't have proof of that in hand today. But he will, he may have to serve some time in Gwinnett for the additional charge that he had there. It's a probation matter. So yes, we would ask the court to commute this case to time served.
Denied. I don't have any basis. This is one of the few cases. He's arrested and convicted of DUI. He's not completed 99% of his sentence, and you want me to just allow him to have 7 days in jail for a blatant disregard of a sentence for DUI.
Well, we'll say, Judge, he was living out of state at the time for a good period of time after this.
Did he do anything while he was out of state with regards, did he take a risk reduction class or do any community service or do an alcohol and drug evaluation like we require everyone else who's convicted for DUI to do?
Right, the community service is the only thing that he completed, Judge. So outside of that, we don't have any proof that he's done anything else, Judge.
Okay, I'll give him credit for the 7 days that he's been in jail. And thank you for doing the community service. That leaves him with 21 days. He will serve out 21 more days at the Fulton County Jail and complete his obligation to this sentence, after which he can then be released to his other hold. And there's no 2-for-1. The sheriff is instructed that this must be a day for day. So 21 more days at the Fulton County Jail. Thank you. This will be recorded as a violation.
Position number 5, 3 South Marlin Gresham.
Give me that name again, please.
Marlon Gresham, position
That-
5.
And actually, can we hold on that? They were unable to locate him yesterday, so we'll need to hold off on this question.
3 South, Mr. Howard would need to speak to Mr. Gresham, so we're gonna hold on that.
This is gonna be on the probation calendar, positions 5 and 6, Mr. McClure.
Okay. I think that's the last case we have on the revocation calendar. This is Tiberius Cordell McClure. And is that correct, Mr. Howard? Is that the correct name?
That's correct, Judge.
All right. This is a probation revocation case 21 CR 0000947Y, in which Mr. McClure was convicted of simple battery and theft by taking. The revocation case number is 23 PV 1331. Mr. McClure, you've been advised of your right to remain silent. Your attorney is Mr. Howard. And Miss Allison, what is the reason for the revocation in this case?
Yes, the defendant failed to pay probation fees in a total of $280. Did not report on June 8, 2023, June 27, 2023, and July 13, 2023. He failed to complete 50 hours of community service. He has 78 days remaining on his case. Probation is recommended for time served.
Judge, he's been in custody 9 days. We'd ask the court to accept that recommendation.
Ms. Tyson, any prior probation revocation matters with regards to Mr. McClure?
One moment, let me look through it.
And Officer Allison, did he do the FBIP program?
He was in order to.
Oh, I don't know. I'm just looking to see.
No, Your Honor, this is his only one on his GCIC. He only has 2. This one and the rest that he received probation on.
All right. I will commute this to time served as recommended by the probation. This will be marked as a probation violation. And that concludes his obligations for this case. Thank you.
Thank you, Judge.
Judge, can probation be excused? We're done with probation
Yes,
matters.
thank you very much. Do you have any documents for me to sign? You can direct that to Miss April Champion.
Okay, I will. Thank you. Have a good one.
You too. Thank
Allison,
you.
did you get I sent the address. Did you get it in the chat?
Yes, yes,
Okay.
I did. Thank you.
All right. Deputy Francois, who do we have, please?
This is gonna be on the regular calendar, position 2, Mr. Byrd.
All right.
Judge, this is going to be a negotiated plea.
All right, sir. Thank you. This is State versus Kava Bird, accused of theft by shoplifting, case number 23 CR 6205J. Mr. Bird, you've been advised of your right to remain silent, and your attorney is Mr. Howard. What's the recommendation from the state, please?
Good morning, Your Honor.
Ms. Oningsel.
The offer from the state is a 12-month probationary period with service of 16 days. He gets credit, I believe, for 8 days. Balance probated, stay away from the location at Five Below, which is 7591 North Point Parkway in Alpharetta.
And actually, Mr. Winner, this is a balance suspended off of, right, so.
Thank you. I
I'm
apologize.
suspended. Okay, thank you. And Mr. Howard, does your client agree, and do you stipulate to the factual basis, venue, and ID?
We do, Judge.
Thank you. Mr. Byrd, please raise your right hand. Do you solemnly swear and affirm the testimony you provide will be the truth?
Yes, I do.
Thank you. Have you consumed any medication or alcohol?
No, ma'am.
And have you understood the proceedings?
Yes, ma'am.
Are you satisfied with your attorney?
Yes, ma'am.
And has it been explained to you that if you decide to enter a guilty plea to this charge, that it would be added to your record?
Yes.
And if you have 3 or more shoplifting convictions on your on your record, any subsequent arrest for shoplifting will be a felony charge?
Yes.
Are you still willing to go forward with this plea?
Yes, ma'am.
And do you understand that you'll be waiving your right to a trial? You will not be able to confront your accuser in a court of law before a judge or a jury. You will not be able to challenge the evidence and the witnesses brought before you. And you will not be able to have the state try to prove the charge against you beyond a reasonable doubt. Are you prepared to give up these rights?
Yes, ma'am.
How do you plead to one count of theft by shoplifting?
Yeah.
Repeat.
Guilty.
Your sentence is 12 months to serve 16 days, credit for time served 8 days. Balance is suspended. You are to stay away from the Five Below store at that North Point Parkway location. If you return, you'll be arrested for trespass again. Thank you.
Thank you.
Position 4, Mr. Davis.
Mr. Howard, is this still a non-negotiated plea?
I believe so, Judge. I don't believe the state is, I hadn't talked with Ms. Elena Allen about it, but the jail time obviously is the issue. I don't know if there will be any change in their position.
Okay, this is case 23 CR 6207A. Mr. Jamil Davis is accused of battery at a public transit vehicle or station. Mr. Davis, you've been advised of your right to remain silent. Your attorney is Mr. Howard. And Ms. Allen, what's the recommendation from the state?
The recommendation, Your Honor, or the offered plea in this case is a 12-month sentence, serve 90 days, credit for, I believe, 24 days, and the balance probated, a 12-week anger management awareness class, and absolutely no contact with the victim in this case, Mr. Seth Napier, as well as a stay-away order from the East Point MARTA station. That's 2848 East Main Street in East Point. This is an assault on a stranger while riding a MARTA train. The victim is actually on Zoom, Mr. Napier. We have received medical documentation. He is still receiving medical care. He has lost work. This is captured on surveillance. This is a eastbound train number 692, where the defendant approached the victim, yelled slurs at him, threatened to stab him with a knife, and then assaulted him, causing bleeding lacerations to his head, his left eye, and his ear, for which he now has scars. He received stitches and is continuing again with medical care, Your Honor.
Right. And Ms. Tyson, what's the prior history for Mr. Davis?
He has 9 arrest cycles beginning in 2019. He has a misdemeanor willful obstruction out of Douglas County, February 2020. He has an FTA out of Douglas County in 2020. He is on a he's under first offender sentence for a felony case in Douglas County.
All right.
For aggravated assault. Let's see, 2 counts of aggravated assault and 1 count of possession of firearm or knife during the commission of or attempt to commit certain felonies. That disposition date was February 2023, and he received 10 years probation on.
All right.
He has another FTA in 2022, another misdemeanor, not willful, let's see, disorderly conduct out of Clayton County, and that's from February 2023 also. And he has 2 additional FTAs. And then his last arrest is the case that's on the calendar, it's transferred over. It was a felony terroristic threats and acts and a battery in public transit that was transferred to state court.
Okay. And Ms. Allen, do you know if he's got a ban from MARTA at the present time?
I don't believe he had been banned when this incident occurred. I can inquire as to whether they intend to ban him.
Okay. All
But
right.
we certainly would like to stay away.
Okay. Mr. Seth Napier, my name is Judge Law, and we are addressing the case involving Jamil Davis. If you would like to contribute to this hearing, you would need to unmute and start your video. Otherwise, we will move on with this particular plea hearing. Mr. Seth Napier.
Yeah, I'm on here.
All right, could you please start your video?
It's not giving me access to.
Unfortunately, I cannot let you testify unless we have you on video. That's part of the open court proceeding mandate.
All right, give me 1 second. Sorry.
All right, Mr. Howard, while we are waiting for Mr. Napier, I will be glad to hear your side of the matter.
Judge, Mr. Davis is 26 years old. He is a lifelong Georgia resident. He attended Creekside High School right here in the metro Atlanta area. At the time of his arrest, he has been working for a staffing company that's provided him with a number of jobs, most recently with a company called Woodbridge. They build car parts for foreign cars. He's also worked at the Marriott Hotel in connection with that staffing agency. And he believes, that upon completion of his requirements or upon release from custody, he will be able to maintain or resume employment with them. He does have one minor child, a 6-year-old, that he helps to support as well. And Judge, Mr. Davis is willing and came willing to take responsibility for his actions on this particular day. Although we dispute some of the facts, the substance we do agree, and he has admitted to and is willing to acknowledge that he's in need of the anger management and is willing to start that as soon as possible. And Judge, we asked the court to make this a sentence of 12 months, serve 48 days with credit for the 24 days so that he can be released to probation where he would be monitored so that he can begin the anger management courses, which will address, maybe some of the issues that contributed to this particular incident. So that's our request, Judge, that the jail time just be reduced so that he can go ahead and begin the anger management outside of the custody of the Fulton County Jail. All
right, thank you. Mr. Napier, I did see you pop in for a second. Yes, good morning.
Yeah. Good morning.
If you could please not move around because it really disrupts with the, okay. May I place you under oath? Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
I do.
All right. The state has recommended that Mr. Davis spend additional jail time prior to being placed on probation, where then he would have to complete anger management classes, have no contact with you, and report to probation every month until the remainder of his 1-year sentence is completed. The defense has asked that Mr. Davis be given credit for the time that he's been served in jail, be released immediately on probation to complete the anger management classes and report to probation, as well as have no contact with you. Do you have an opinion with regard to the two alternative recommendations?
Yeah, I'm not sure I necessarily agree with that. I mean, given the circumstances of the situation, I mean, there obviously is video and audio of the instance happening. And, in my honest opinion, the words that were said, I would consider that to be a hate crime. Also, I'm continuing not only therapy, but medical care for my eye. I've got subconjunctival hemorrhages in it, which can lead to cataracts and other things. So I got to continue to follow up with the eye doctor. On top of that, chronic headaches. I've lost work. It's still affecting me at work. And, the situation that arise, just sitting there and not saying anything or doing anything, I don't think a situation like this constitutes jail time.
Okay. Thank you, Mr. Napier. Anything else, Mr. Howard?
And Judge, we acknowledge Mr. Napier's, how this has affected him. And again, Mr. Davis is not disputing his guilt in this incident. And we just would like for him to have the opportunity to go ahead and start getting the classes done. He has spent 24 days in custody on this, so which is not an insignificant amount of time. We would ask the court to allow him to be released to proceed on probation.
Given Mr. Davis's criminal history record, given the egregious circumstances of this particular incident, and given the fact that he was already on felony probation while this alleged incident took place, the court is going to accept the state's recommendation that Mr. Davis serve 90 days in jail, be given credit for 24 days. And once his additional jail time is completed, that he report to probation every month, and that he is required to have no contact with the victim and complete the anger management classes. Given the state court's decision, would Mr. Davis like to proceed with the plea, or would he like to have the case arraigned and further notice for trial?
Just a quick second, Judge.
Yes, sir. Make sure you're muted. Thank you.
Judge, Mr. Davis is still wanting to resolve the case today, Judge, understanding that the court will accept the state's recommendation.
All right, sir. Mr. Davis, please raise your right hand. Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes, ma'am.
All right. And Mr. Howard, do you stipulate to the factual basis as articulated by Ms. Allen, the venue and the ID?
We do, Judge.
All right. Mr. Davis, have you consumed any medication or alcohol?
No, ma'am.
And have you understood the proceedings so far?
Yes, ma'am.
Are you satisfied with your attorney?
Yes, ma'am.
And is anyone forcing you or inducing you to take this plea today? I'm sorry, I didn't hear a response. Is anyone forcing you or inducing you to take the plea today?
No, ma'am.
All right. And Mr. Davis, if you decide to enter a guilty plea to this charge, you would have to give up your constitutional right to go back to court and have a trial in front of a judge or a jury. You would have to give up your right to be able to confront your accuser, challenge the evidence brought against you, cross-examine and examine witnesses, present any defenses if you choose to do so, and have the state try to prove the charge against you beyond a reasonable doubt. Are you prepared to give up these rights?
Yes, ma'am.
All right. How do you plead to one count of battery in a public transit vehicle or station?
Guilty.
I accept your guilty plea. Your sentence is 12 months to serve 90 days. That's 90, while you're given credit for 24 days. Once you've completed the additional jail time, you will report to probation at the first available business day, which will be Monday, Tuesday, or Thursday. Is that correct, Mrs. Thomas? I'm just blanking out right now. Mrs. Thomas, it'll be Monday, Tuesday, or Thursday, correct?
I think it's Ms.
I'm sorry, Your Honor. Yes, Monday, Tuesday, or Thursday.
Correct. Okay, thank you. And when you report to probation, it has to be before 3 p.m. on the first available business day upon being released from jail. While you're on probation, you will complete 12 weeks of anger management classes, and you will enroll in those classes within 60 days of being released from the jail. Please understand that you must enroll in those classes within 60 days of being released from jail. At all times while you're on probation, you are to have no contact with Seth Napier. You are to stay away from 200 yards away from Mr. Napier, no matter where he's located, whether he's at a MARTA station, at his place of employment, at a doctor's office, at home, wherever he's physically located, you have to stay 200 yards away from him, and you cannot communicate with him in any way, form, or manner. You are not to use any MARTA facility that is at the East Point MARTA station, or if there is a ban from all MARTA facilities. So if you have a suspension from MARTA right now from all their facilities, trains and buses, you cannot go back to MARTA. However, if the ban or the suspension is concluded, then while you're on probation, you cannot return to the East Point Model Station, which means that if you're on a train, you cannot disembark at the Model East Point Station, and you definitely cannot embark from that Model Station. You will report to probation every month, and you will pay probation fees every month. That concludes your case. Thank you.
Thank you, Judge. All right.
Position 7, Mr. Sharon Harris.
Right. Deputy Milton, let me know when I can address 3 South and ACDC, please. I think they have one each there.
No.
All right. Thank you. Sharon Harris is position 7, 23 CR 5962F. Just one second. Okay. Mr. Harris is accused of battery, family violence, and simple battery, family violence. Mr. Harris, you've been advised of your right to remain silent, and your attorney is going to be Mr. Howard. Mr. Howard, shall I arraign the case, or will you be filing a waiver of arraignment?
We'll be submitting a written waiver of arraignment.
All right. Please direct that to Ms. Champion. And Mr. Harris, your attorney is going to be submitting your not guilty plea through documents, and your arraignment is waived, basically, and your case is going to be further notice for trial. I understand that your attorney would also like to have your bond revisited. So let me see. Mr. Sharon Harris received his initial appearance on October 6th, and a bond order of $2,000 surety was issued by Judge Williams. And no further contact, and stay away. Yes, sir.
Judge, Mr. Harris is 45 years old. He has lived in Georgia for pretty much all of his life, for more than 30 years. He was recently laid off and wasn't working. But prior to that, he was working for Hodge Construction as a laborer, which he still is able to pick up work for them from time to time. But money has been an issue recently, which is why, there hasn't been, he hasn't been able to bond out on the bond as it's currently set. He does have a total of 6 children, but 3 minor children, ages 17, 16, and 13, which he does not share with the complaining witness in this case, but he's actively involved with them as well, and certainly needs to maintain employment to continue to meet his obligations to take care of his children. Judge, we would ask that the parties, it's my understanding, have been married for the past 10 months. We were not able to reach her. I don't know if the state was able to reach her to determine what her desire is as it relates to contact, but we certainly would like for Mr. Harris to be able to return to his home at 2955 Birch Avenue. And so our request is that it be no violent contact and there not be a stay away. And we'd ask the court to reduce his bonds to a signature bond. He does have holds, Judge, that he will be released to. He has both a Newton County and a Gwinnett County hold. So he would not be released from custody even if the court granted a signature bond, but he would be able to, navigate through those holds if the court would be willing to reduce that to a signature bond in this case, which is our request, Judge.
All right. Looks like the last time he was in the Fulton County Jail was November 9th, 2013. Ms. Tyson, can you give me his brief report after 2013?
Yes. Two violations
Oops, I'm sorry, go ahead.
of probation. He has he has a felony conviction out of Fayette County for aggravated battery, and that's from February 2016. He has a misdemeanor conviction out of Newton County for aggravated assault that was amended to a misdemeanor battery, and that was October of 2016. Let's see, and
That's
it looks
good.
like
That's good, thank you.
okay.
And those are the 2 holds, Mr. Howard?
Appears so, Judge, yes.
All right, I think the bond's very reasonable, given that history. Thank you.
Thank you, Judge. So we'll submit the waiver.
All right, while courtroom 2 is waiting, I am going to, Deputy Francois, I'm going to 3 South. 3 South, is that still the Mr. Gresham?
It is.
All right, I think we're waiting for counsel to speak. I saw Miss McLeod appear and she has a client. Miss McLeod? I'm sorry, you're on mute, Miss McLeod. Good morning.
Good morning, Your Honor. I'm
Morning.
trying to get in touch with ACDC with Union City to speak with my client.
And your client's name is?
His name is Javaris Riley, Your Honor.
Oh, Mr. Riley, was he at ACDC or 3 South?
Yeah, yes.
He is in Union City, Your Honor.
Okay.
Excuse me, Ms. McLeod, I put in the chat the jail telephone number. They would like. for you
I
to-
know, I've been calling, but no one
Okay.
answers.
All right.
I
thank you.
saw it.
Was that the number for Union City?
Yes, I received 2 numbers from Miss Grace, but they don't answer either.
Deputy Milton at ACDC.
What's your name, sir?
Do you have a Mr. Riley there that Ms. McLeod can speak with her client? I don't know if Deputy Milton's available. All right, I'm sorry, Ms. McLeod, as soon as Union City makes Mr. Riley available, we'll have an opportunity to speak with him.
That's fine, Your Honor.
All right, thank you.
I'm sorry, excuse me, Judge Law, Ms. McLeod, you said
Yes.
at Union City?
Yes, he's in Union City. I have 2 numbers, 404-613-6635 or 404-613-6637. I've tried both several times, but no one answers.
Okay, I'll try to give them a call myself as well.
Thank you.
All right. Mr. Howard, is that your client, Mr. Gresham at 3 South?
Yes, if I could have, if there's a phone, if they could call me.
There's no phone. Gotta do a breakout. No phone.
That'd be better. So just, if you can put me in a breakout, Judge, with 3 South.
Do you have a laptop? Yes, you do. I do see that you have a laptop.
Yes.
Can you activate that laptop and we will place 3 South and Derek Howard in a breakout, please?
Will do, Judge.
All right, thank you. And then Mr. McLean, we can take your next case.
Mr. Yarborough?
This is position 26.
All right. And ACDC, Deputy Milton, I do see a young lady at ACDC, but I don't know who's managing the Zoom there. So Mr. Derek Howard, please join the breakout. Okay. And this is position 26.
Adam Yarborough, 26, Your Honor.
Thank you, sir. And what is I'm sorry, I haven't printed out these PD. Okay, I got it. Okay, this is going to be a negotiated plea.
Correct.
This is State versus Adam Yarborough, accused on case number 23 CR 5951E. And he has 5 charges brought against him as follows: operating a vehicle without the proper lights, fleeing or attempting to elude a police officer by driving, 2 counts of willful obstruction of a police officer, and driving while license suspended or revoked. This is from an August 22nd, 2022 incident. And Mr. Yarborough, you've been advised of your right to remain silent, and your attorney is Mr. McLean. May I place you under oath for purposes of the plea?
Yes,
Do you
ma'am.
solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes.
Thank you. Ms. Allen, what's the plea recommendation for Mr. Yarborough?
This is Mr. Brandon Thomas's case, I believe.
Oh, Mr. Thomas, okay. And there he is.
Sorry.
Mr.
Your
Pierre Thomas, good morning. How are you?
Good morning, Your Honor. How are you?
Doing well, thank you.
The recommendation on Mr. Yarborough will be on count 1, 12 months probation with a $265 fine. Count 2, it's going to be 12 months probation to serve 30 days with credit for the 16 days that he's already served in custody. Balance probated with a $1,000 fine and 40 hours of community service. Count 3 will merge with count 4. Count 4's recommendation will be 12 months probation concurrent with count 2. Count 5 will be 12 months probation, a $500 fine, license suspension for an additional 6 months per the statute, Your Honor, concurrent with count 4. And that total is going to be 12 months to serve 30 days, credit for the 16 days that he's already served, balance probated, and a total fine of $1,765. And lastly, 40 hours of community service.
Phew, okay. Count 2 is 12 months to serve 30 days, credit for time served 16 days, probation, $1,000 fine, 40 hours of community service. Count 1 is concurrent to count 2,
Yes, Your Honor,
and that is to pay a $265 fine, correct?
that is correct.
Okay. Just make sure that's concurrent. Count 3 merges into count 4.
Yes, Your Honor.
Count 4 is 12 months to serve 30 days, credit for time served 16 days, pay a $500 fine. Would that be consecutive to count 2?
It's everything's going to be concurrent, Your Honor.
Everything's going to be concurrent.
Yeah,
Okay.
because the total is 12 months probation and then the total
Okay.
of that fine.
And with regards to count 5 on the willful obstruction, you're asking for a 6-month license suspension, correct?
Yes, I think that would be automatic with the DDS, but we just wanted to state it on the record per the statute.
Okay. And then on count 5 is 12 months credit for time served, 16 days to pay an additional fine.
Yes, the total fine will be $1,765.
For which one?
So count 1 is going to be $265. Count 2.
No, I got it. I got it. Okay, yes. Okay, so driving while license suspended or revoked is the fine will be $1,765, which is concurrent to the total of all the other fines. Correct? He's not paying an additional $1,765.
No, Your Honor.
Okay, understood. And you're also asking for 40 hours of community service. Is that concurrent to count 2? Because that's what you're asking for.
Yes, it's concurrent.
Okay, so total, he'll be on probation. He'll report every month. He has to pay $1,765 in fines, and he has to do 40 hours of community service, and his license will be suspended for 6 months.
Yes, and then the 30 days in custody and credit for the 16 days.
Correct. Okay, got it.
Thank you.
Mr. McLean?
Yes, Your Honor, by tradition, when we ask to convert community service hours to fine or vice versa, we're not departing from it being a negotiated plea. That's my understanding based on experience here. Your Honor, he will get out there and make as much money as he possibly can to be working on these fines, and feels that because of the, I don't want to say burden, he's going to be able to get it done, but he's going to try to make so much money as fast as he can to pay these fines, that it would be actually better for him to have $400 additional fine instead of the 40 hours community service, if that would be okay with everybody.
So he does not want to do community service, but he wants to pay $400 additional dollars. Is that what you're saying?
Right, Your Honor. He'd love to do that service if he had time, but he thinks he's going to be working his rear end off.
He has 12 months to do it. That's denied.
Okay, thank you, Your Honor.
Anything else?
Nothing else, Your Honor.
Okay. And does your client accept the terms, and do you stipulate to the factual basis, venue, and ID?
He does.
All right. Mr. Yarbrough, I don't remember if I placed you under oath. If you please raise your right hand. Do you solemnly swear and affirm your testimony you provide will be the truth?
Yes.
Thank you. Have you consumed any medication or alcohol recently?
No, ma'am.
And have you understood the proceedings so far?
Yes, ma'am.
And are you satisfied with your attorney?
Yes.
Is anyone forcing you or inducing you to take this plea?
No.
And do you understand that if you decide to plead guilty to these charges, not only will your license be suspended, but then you'll need to report to probation every month, and you cannot afford to be arrested or lose your probation status in any other way, form, or manner.
Yes.
And has your attorney explained to you that in entering this plea at this stage, you'll be giving up your right to a trial before a judge or a jury? You will not be able to confront your accuser, to confront witnesses, to examine and cross-examine them, to challenge the evidence brought against you, and have to have the state try to prove the charges against you beyond a reasonable doubt. Are you prepared to give up these rights?
Thanks, ma'am.
How do you plead? To one count of operating a vehicle without proper lights, driving or fleeing or attempting to elude a police officer while driving, one count of willful obstruction of an officer, and driving while license suspended or revoked.
Yeah.
I accept your guilty plea. With regards to count one, operating a vehicle without the proper lights, that's going to be 12 months to serve credit for time served 16 days. And you will need to pay a $265 fine. With regards to count two, which is concurrent, is 12 months to serve 30 days, credit for time served 16 days. You will be reporting to probation, where you will have to pay a $1,000 fine and complete 40 hours of voluntary community service at any nonprofit agency that's not a school and not a church. Count three will merge. Count four is 12 months, serve 16 days. You'll be placed on probation to pay a $500 fine, and your license will be suspended for 6 months. And for count five, driving while license suspended, is 12 months to serve 30 days, credit 16 days, and that's concurrent. And the fine will be concurrent to the two other charges that have been sentenced, and the 40 hours community service will also be concurrent. So in total, once you are released, you will report to probation. You report to probation next Wednesday before 3 p.m., which is any holds, Mr. McLean?
You don't have any holds, do you? Yes. Oh, you do. I have, I'm sorry, Your Honor, my papers are to my right. Henry County holds, we should be able to take care of that expeditiously. It's a small matter, I think you told me. Yes. That's right. It was a small matter, he believes, so he'll be going to Henry County to take care of that.
Ms. Tyson, do you have a record of a hold for Mr. Yarbrough?
It's listed on his jailing screen. I didn't see anything listed on GCIC for a hold, but it is on his jailing screen though.
All right. I'm not sure if Henry County is going to come pick him up or whether he has to travel to Henry County, but if he has to travel to, if he's released and he has to travel to Henry County, then he needs to report to probation first, which will be next Wednesday. Then after that, he can go to Henry County. But if Henry County comes and picks him up, then within 48 hours of being released from Henry County, he needs to report to probation at the first available business day, which will be either a Monday, a Tuesday, or Thursday. When he's on probation, he will report every month. He will need to pay a total of $1,765 in fines, plus any court costs or any other related charges. He will need to pay his probation fees. He will need to complete 40 hours of community service. He will report every month for the remainder of the 12 months, less 16 days. No driving unless he has a valid driver's license or a qualified limited permit issued by the Department of Driver Services. Not a limited permit, a temporary license, a valid registration for the vehicle that he operates, and adequate insurance. Thank you.
Thank you. Oh, by the way, we've all been doing the same exact thing. When I first met him, I said, "Your name's Yarbrough," and they left out an R, didn't they? And said, "No, it's really Yarbrough. It only has one." Thank you.
All right. Thank you.
Excuse me, Judge Law, before you guys start on 3 South, I just have a quick announcement. For ACDC, Ms. Milton had stepped away. So after you guys are done with 3 South, the female that's sitting up front is going to be position 25, Ms. Wimbish. And again, Ms. Milton stepped away doing another calendar.
Okay. Are we doing the 3 South with Mr. Gresham or going to medical?
We can go to medical. We have position number 8, Mr. Thomas, Mr. Thompson.
All right, and Mr. Howard, I'll go to you next after this for Mr. Gresham. This is state, what's this, Mr. Thomas, case number 23, CR 5940H. And did you say this was position 8?
It is, Your Honor, and that's my case.
All right, this is State versus Keith Kelly. That's not medical. You said Thomas. Is that Keith Kelly?
No, that's Mr. Kelly.
I spoke with a gentleman yesterday.
Oh,
and
yeah, that's Mr. Kelly.
I just want to be sure. Thank you. Mr. Kelly has been accused of improper or erratic lane change, reckless driving, and willful obstruction of an officer in case number 23 CR 5940H. Mr. Kelly, you have a right to remain silent. Anything you say in open court, your statements can and will be used against you. And you have a right to an attorney, and representing you this morning is Mr. McLean, Mr. Derek Howard, sorry, Mr. Derek Howard. And Mr. Howard, how are we proceeding in this matter today?
Judge, this is a negotiated plea.
All right. Mr. Kelly, please raise your right hand. Please unmute medical. Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yeah.
Thank you. Ms. Allen, what's the recommendation for Mr. Kelly?
Your Honor, 3 counts in this case. The count 1, 12 months probation. That's going to be concurrent on all 3 counts. He's to serve 30 days and get credit for the 16 days that I believe he's already served, and the balance is probated. On count 1, there's a $265 fine. Moving to count 2, reckless driving, 12 months again with credit, and a $500 fine, as well as a driving course approved by DDS and 40 hours of community service. Count 3, just concurrent 12 months of probation with credit.
All right. Mr. Howard, does your client accept these terms, and do you stipulate to the factual basis, venue, and ID?
We do so stipulated, and per our discussion yesterday, he agrees to the terms, Judge. The only additional consideration we'd ask is that he wants to sort of resolve these matters quickly. Once he's able to pay the fines and complete the requirements and conditions, we would ask that his probation be allowed to terminate.
I'll put him on non-reporting probation. Any objection, Ms. Allen?
No, Your Honor.
All right. If we can unmute medical, please. Mr. Kelly, have you consumed any medication or alcohol recently?
Excuse me?
Have you consumed any medication or alcohol recently?
No.
And have you understood the proceedings?
No.
You've not understood it?
Yeah.
Have you understood what's going on in your case so far?
Yeah.
Are you satisfied with your attorney?
Yeah.
Is anyone forcing you to take a plea today?
No.
Has your attorney explained to you that if you plead guilty, you need to pay attention? If you decide to plead guilty today. All right. Medical, can we shut the door? Is that possible? Thank you. I just want to make sure that you understand that if you enter a guilty plea, you will be giving up your right to a trial.
Close it, man. Close it, I'm talking to these people, man.
Mr. Kelly,
I'll be honest with you.
can you hear me?
I'll be honest with you. Yeah, I'm listening. When can I talk? When can I get a chance to talk? Can I get a chance to talk?
I didn't realize you wanted to say something. Mr. Howard, did your
Mr.
client
Kelly?
want to say something?
Mr. Kelly,
This like talking about, am I sure? Am I sure? You know what I'm saying?
Mr. Kelly,
I
just
do have a question.
okay, just sit tight. We talked at length yesterday. If you have additional questions, we can take a sidebar and talk more. But right now the judge is asking you the questions we discussed yesterday. So just you need to respond to her questions. And if you have any other statements, you and I we can talk further. So is that what do you want to proceed with the plea, or do you want to have you and I to have more discussion?
I'd rather me and you have more discussion.
Okay, so Judge, if we could come back to him, I'm ready on Mr. Gresham as well.
All right, Medical, please mute, and Mr.
We can do a
Kelly, you need
breakout.
to be seated. Thank you very much. This is State versus Mr. Gresham, and that is going to be position. I'm sorry, folks, if you can.
Position number 5.
Thank you, Deputy, appreciate it, thank you. This is State versus Marlon Gresham, case number 23 CR 6182F. Mr. Gresham was accused of willfully rendering or furnishing a false fraudulent report and criminal trespass. And the allegation was from October 10th, 2023. Mr. Gresham, you have a right to remain silent, and your attorney is going to be Mr. Howard. Mr. Howard, how are you going to proceed with this case?
Judge, this is going to be a negotiated plea.
All right. And Mr. Gresham, if you please raise your right hand. You solemnly swear the information you provide will be the truth to the best of your knowledge.
Yes, Your Honor.
Thank you. Ms. Allen, is this your case?
Yes, Your Honor, it is.
All right. And what is the state's offer for the 2 charges?
We will be null prosing count 1 and moving forward on the criminal trespass. The offer in this case is 12 months probation with 20 days to serve, credit for 10 days, balance suspended, stay away from all MARTA property. There is an active suspension, and that was put in place August of this year and is good through September of next year.
So it's a 1-year suspension?
Yes, Your Honor.
Mr. Howard?
Judge, that's our understanding is we balance suspended, and he's aware of the suspension, and we discussed that as well. So we stipulate to a factual basis, venue and ID, and we'd ask the court to accept the state's recommendation.
Thank you. Mr. Gresham, have you consumed any medication or alcohol?
No, Your Honor.
And have you understood everything going on so far?
Yes, I have.
Are you satisfied with your attorney?
I am.
And is anyone forcing you to take this plea today?
No.
Has it been explained to you that if you plead guilty to criminal trespass today, you would have to give up your right to a trial? You will not be able to confront your accuser, challenge the evidence brought against you, and have the state try to prove the original charges against you beyond a reasonable doubt. Are you prepared to give up these rights?
Yes, Your Honor.
How do you plead to 1 count of criminal trespass?
I plead guilty, Your Honor.
I accept your plea. Your sentence is 12 months to serve 20 days, credit for time served, 10 days. You'll be released. The balance will be suspended. You don't have any other obligations except one. You have to stay away from all MARTA property, trains, buses, stations, bathrooms, parking lots, and so forth for 1 year until next September 2024.
I understand, Your Honor.
All right, that concludes this case. Thank you.
Thank you, Judge. And if I could be put in a breakout with medical.
All right, Mr. Howard and the Zoom panel, medical deputy at medical.
The man got down, wait, 200 some pounds.
Okay, Judge.
All right, if you could put him in a breakout room, there will be a message to go in a breakout room. Or if Miss Melissa, if you can go ahead and put that panel in a breakout room as soon as possible, please. Thank you. ACDC, is that Miss Wimbush?
Yeah.
All right, Mr. McLean, is that your client?
Yes, Your Honor. The nature of this case is such that we would need to go into a breakout if possible.
All right. And Miss Grace, can you arrange another breakout room for Mr. McLean, please? This is position 25.
Okay, Mr. McLean, in what courtroom, Judge?
Courtroom 2, because there's no one in courtroom 2, and ACDC goes into a breakout.
Okay.
Mr. Howard and Derek
Noted.
Howard needs to be in a breakout with medical.
He is.
He is?
Yes, he's on his laptop.
Okay. I have a person on iPhone wearing a denim jacket. Yes.
I'm Ariana Wonder's mother.
Okay, you need to mute your screen until your case is called or your relative's case is called.
This
You
is,
just called it.
Your Honor, this is Ms. Wimbish's mother.
Oh, I see. Do you need her in the breakout with you?
Not at this time, Your Honor.
All right, please mute, ma'am.
Okay.
Mute your panel. Thank you. All right, folks, we are in a brief recess until Mr. McLean and Mr. Howard return from their conferences. And if the jail could identify where Mr. Riley is so that Ms. McLeod, or I guess she's must be speaking with her client. All right, and Miss Allen, we have 2 bench warrants at 11 o'clock.
Yes, Your Honor.
Who will be addressing those matters?
I'll be addressing position number 1 and Mr. Thomas will be addressing position number 2.
All right, and do you know if both of them have been, have retained counsel, whether I see Mr. Mason may be represented by Public Defender's Office?
I'll go look and see what I can find. Mr. Howard, do you know?
Right. Mr. Howard, are we ready to proceed with Mr. Kelly?
No, Judge, my battery died as soon as they sent me to the breakout and I'm just logging back on. So I need to go to the breakout with 3 South again.
Medical, you mean?
But medical, I'm sorry. Yeah.
All right.
Okay.
Medical, I'm so sorry, Mr. Howard had a technical problem, but I'm going to put you back in the breakout room so that Mr. Kelly may speak to his attorney. Ms. Grace? Ms. Melissa, if you could put Mr. Derek Howard in medical in a breakout, please.
Yes, ma'am.
Thank you. All right, Ms. Allen, we'll be in a brief recess until
Absolutely.
council's appear. All right, thank you. All right, Mr. McLean, are we ready to address position 25? If you could unmute, please.
There we go, in the unmute. Your Honor, to do that, could we please have a breakout room between the state and me and the court?
Repeat again. A breakout with you, Miss Allen, and who else?
And the court itself, Your Honor.
All right. Miss Allen, are you the prosecutor for Miss, or is that Mr. Peter Thomas? All right.
We would both need to be there, Your Honor. Thank you.
All right. Miss Grace, first of all, please mute the iPhone on the screen. Thank you. And then place me, Mr. Pierre Thomas, Miss Allen, and courtroom 2 in a breakout, please.
Yes, ma'am.
Yeah. Ms. Wimbish. Yeah.
Courtroom 2, please mute. Mr. McLean, please mute your screen. We're waiting to get into the breakout.
You gotta be mad at me, man. Y'all gotta be mad at me. Y'all ain't help me all the time, non-communication.
All right. This is Ariana Wimbish, case number 23 CR 6181E. Ms. Wimbish is presently at the ACDC location. Ms. Wimbish, we have discussed this matter with your attorney, and they are going to be undertaking additional steps with regards to your case. So your case is going to be reset to 9 a.m. October 26th. And at which time your attorney will consult with you and advise you as to the steps that they are planning to take. Ms. Kasha, please make a note that if October 26th is not a viable date, you and Mr. McLean would need to advise the clerk's office accordingly. And let me see, Mr. McLean, Ms. Wimbish's mother is also on the Zoom. Do you have her contact information?
I do, Your Honor. So I'll stay in touch with her mom and Ms. Wimbish. I'll be visiting you soon.
All right. Thank you. Please unmute ACDC. All right. There isn't anyone there to unmute the screen. Ms. Wimbish, Mr. McLean is your attorney and he will be visiting you soon, or we'll have to come and he'll have to come in. Oh, there you go. Yes, Ms. Wimbish, did you have a question?
Reset. This need to be discussed now. I don't want to keep sitting here. What we got to reset it for?
You have a $2,500 bond in your previous case, which you have made bond, but in your new case, you have a $6,000 bond. If you make bond, then you definitely can be released on bond.
So what's the problem? Why I gotta keep being the other case? Why we can't just discuss this now? What else I gotta do? I don't want to keep having to discuss these.
Mr. McLean?
If you do not make your bond, I will be seeing you within the week and we'll discuss all this stuff, okay? Thanks.
So what about the 45 days? What about all that?
We'll discuss that in detail.
Courtroom 2, please place ACDC and Mr. McLean in a breakout. Mr. Howard, are we ready to address Mr. Kelly?
Hey, what the fuck? This shit is crazy.
All right.
Hey, what?
Okay, we're gonna reset her to the 26th. Thank you.
Excuse me, can I say something?
No, ma'am. I've already told Mr. McLean to call you on the phone. Do not say anything on Zoom. Do not say anything on Zoom. Thank you. Mr. McLean, your client's case is reset to the 26th. ACDC, Deputy Milton, we will see you on the 26th. Thank you.
Thank you, Your
All right.
Honor. Your Honor, can we have Deputy Milton call the extension 612-404-612-2392, which is one of the desk phones here?
All right, she's off the Zoom, so, oh, there you go. Deputy Milton, when you get a chance, could you please call the main Wright Street Jail, courtroom 2? Thank you. Mr. Howard, are we ready to proceed with Mr. Kelly?
Judge, yes, after further discussion, we're gonna, this is gonna be a not guilty today, and I'll submit the written waiver, Judge, so we don't need to do the formal arraignment or anything of that nature. So we just ask that it be not guilty, reset for jail jury.
All right. Mr. Kelly, your attorney is going to file a not guilty plea on your behalf, and the case is going to be further notice for trial. Thank you.
Thank you, Judge. Mm-hmm.
Your Honor, I'm calling courtroom 2, the 2392.
22392?
Yeah, they're not picking up.
Mr. McLean?
If he would just come on out here to meet with her. I have another thing at 11.
Okay, we'll do that. Thank you.
Thank you.
All right. We have another case at 4 South. 4 South, who do we have, please?
Position number 9, this is Maggie.
Thank you. This is State versus Deshaun Antoine Mackey, 23 CR 5983F. Mr. Mackey is accused of battery, family violence, willful obstruction of an officer, and loitering and prowling. Mr. Mackey, you have a right to remain silent. Anything you say in open court, your statements can and will be used against you. Where did he disappear to? Mr. Mackey is off screen. All right. Mr. Mackey, you need to remain on screen. Thank you. You have a right to remain silent. Anything you say in open court, your statements can and will be used against you. You have a right to an attorney, and representing you is Mr. Mike McLean. And this is position number 9. This is going to be a non-negotiated plea, Mr. McLean?
Yes, Your Honor. Probably the camera's a little too close to his face. Is that correctable?
All right. For South, can Mr. Mackey hear us?
No, we couldn't hear that well. I don't know why we couldn't get the volume up.
Check your device if the volume is all the way up. I don't know whether it's on a phone or a computer, but just check the computer. There's normally a speaker button on the bottom right-hand corner.
It's already, it's on 100.
All right. Testing. Mr. Mackey, can you hear me?
A little bit.
He said a little bit.
You can put your head as close as possible and let me know if that's okay. Can you hear me now?
Yes.
Okay, we'll leave it at that. All right, Mr. McLean, I'm going to hear the state's offer first. Ms. Allen?
Thank you, Your Honor. This is a case with 3 counts. The offer is concurrent. Count 1 is battery, family violence. That's a 12-month probated sentence. Serve 180 days with credit for 14 days. Balance probated, complete family violence intervention programming, 40 hours of community service. Have no further contact with the victim in this case, Ashley Burton, B-U-R-T-O-N. Stay away from the location at 532 Cleveland Avenue Southwest. Counts 2 and 3 would be 12 months concurrent. No other additional conditions or requirements.
Mr. McLean?
Yes, Your Honor. Mr. Mackey would like to ask the court to consider instead of the 180, 60, and the calculation of the math would result, therefore, instead of an extra 76 days before he starts his probation with the FVIP, that would cause it to be, I believe, 60 divided by 2 is 30. Minus 14 would be 16, 1/6 instead of 7/6. He just felt the time, he just felt like he's able to get on probation, give some extra jail time, and start learning what he needs to learn from that FVIP course. But he was asking to reduce the amount of extra jail time.
All right. Ms. Tyson, may I have his GCIC, please?
He has 7 articles beginning in 2012. He has a misdemeanor conviction for simple battery, criminal trespass, and theft by taking out of Clayton County. Disposition date is February 2013. He has another misdemeanor conviction out of Clayton County for criminal trespass, and that's from September 2022. He has a felony conviction out of Clayton County for terroristic threats and acts, battery, family violence, first offense, and criminal trespass from October 2022. He received 5 years probation on that case, so he's still on probation.
That's
Another
good.
felony conviction.
That's good. Thank you, Ms. Tyson. Appreciate it. All right, Ms. Allen, did you want to articulate the factual basis or anything else to add with regards to this case?
Yes, Your Honor, briefly. So you just heard the criminal history in this case. When this gentleman was arrested on October the 6th, he was found to have an outstanding warrant out of Clayton County for a probation violation that would be related to the felony case you just heard about. That is a DV case as well. The multiple DV cases and convictions out of Clayton County actually involve a different victim. In this situation, police were called about someone loitering and prowling in the area at Metropolitan Parkway. They responded and found the defendant hiding in a locker area near the Dollar General. He ran from police into the woods, but eventually complied and came and spoke to police. 911 then alerted police on scene that they had received a call from the victim in this case, Mrs. Ashley Burton, who reported she'd been bitten during an altercation with her boyfriend. She was bleeding from a finger on her hand. She reported that they'd gotten into a verbal altercation. He'd left the location where they had been living for a period of time. She'd asked him to leave, and then they were breaking up. He returned, continued to argue with her, and then while she was handing him items, grabbed her hand and bit her. The position of the state is that with multiple convictions for battery, criminal trespass, and just recently felony level simple assault, battery, terroristic threats, there have been ample opportunities to do things like anger management and FVIP at this point. And so a period of jail time is appropriate in this case, given the criminal history and the severity of the incident.
All right. Mr. McLean, I am going to accept the state's recommendation. Would your client still like to proceed with the plea, or would you like to speak with him?
I believe I need to speak to him briefly, Your Honor.
All right, Ms. Champion, if you could put 4 South and courtroom 2 in a breakout. 4 South, you will see a message on your screen to go into a breakout.
Okay, Judge.
Or we may have to put 4 South into the breakout. All right, Ms. Allen, did you get a chance to look at who's representing the bench warrant cases?
Position number 2, I think we are still asking about. Position number 1, you believe was the PD?
Yeah, I saw Ms. Giddings' name on the screen. Okay.
Okay.
Mr. Howard, do you know who's representing the 2 individuals on the bench warrant calendar?
Yes, as was stated, Judge, we're representing number 1 and potentially number 2. Actually, I just need to make a quick phone call to him. I just haven't had a second to do that.
Okay, all right. We'll be in recess until Mr. McLean returns. And then if anybody else in the jail case needs to be addressed, we're waiting. Thank you.
Okay, all right.
Thank you.
Hey, excuse me, Judge Law, let me log off and log back on. Maybe the volume go up a little bit.
Okay, thank you. Miss Grace, please note 4 South is going to be logging back in.
They had some kind of computer issue, which was making them decide to use that other device, and it was just too close to his face. I thought it looked kind of.
Okay, no problem.
It says line 2. That's it.
All right, I've got 2 bench warrant cases for Reynold Mason and Maurice Spigner.
I'll be doing Mr. Mason, Your Honor.
All right.
Or do you know the
I just had someone join on a Samsung phone, but I don't think his audio is connected, so I don't think he'll be able to hear us. Is there a Mr. Reynold Mason? All right. 4 South, if you could unmute.
What about ACDC?
4 South, can you hear us?
Still can't hear that well.
4 South, are you ready to go into a breakout?
We just left the breakout.
Okay, Mr. McLean.
Your Honor, I would like to ask the court to allow to withdraw his guilty plea, and we will plead not guilty at this time.
This is Mr. Mackey, and this was position 9. The plea is withdrawn. Are you filing a waiver of arraignment?
I do have a form for that, Your Honor. I'll fill it out before I leave this room.
All right. Mr. Mackey, your attorney is going to file your not guilty plea for you, and your case is going to be reset for trial. 4 South, can you confirm if you received that, if you heard me?
Yeah, I heard you.
All right, thank you. That concludes that case. Thank you.
We're gonna do position number 3, Clark.
This is Cedric Clark, 4 South, case number 23 CR 5937F. Mr. Clark is accused of criminal damage to property, theft by shoplifting, criminal trespass, and possession and use of a drug-related object. I think that's one other offense, and that didn't print up. Let me just make sure. Position number 3.
It's a battery.
Yes, criminal trespass causing damage to property, theft by shoplifting, criminal trespass, possession and use of drug-related object, and 1 count of battery stemming from an October 4th, 2023 incident. Mr. Clark, you've got a right to remain silent. Anything you say in open court, your statements can and will be used against you. You have a right to an attorney, and representing you is Mr. Michael McLean.
Your Honor, that'll be Mr. Howard. He's on the phone right now concerning a DV case, and asked us to hold for a moment, but he'll represent Mr. Clark.
Okay. Let me correct that. Mr. Clark is represented by attorney Derek Howard. All right, while I'm waiting for attorney Derek Howard to come on screen, Mr. Spigner, can you do an audio test? 1, 2, 3, say something, 1, 2, 3. We cannot hear you. Well, I can't hear him because he's also on the phone. All right. Now he's looking at the phone. So, Mr. Spigner? Mr. McLean is Mr. Howard within earshot?
He is, Your Honor.
Could you let him know that we're ready to address position 3?
I will.
Okay.
And that if he's speaking to Mr. Spigner, we do not have audio with regards to Mr. Spigner.
You heard. Okay.
Excuse me, Judge.
Mm-hmm.
Ms. McLeod just called me and informed me that she can't get in touch with Union City. I've tried both the numbers Sergeant Smith left in the chat for me, and I can't get them as well.
Okay, I'll ask the deputy at 4 South.
Okay,
And that was
thank
for
you.
Mr. Riley, right? Position
Yeah.
15?
Yes,
Mr.
ma'am.
Spigner? Okay.
Hello?
Yes, Mr. Spigner,
Yes.
who is your attorney?
Judge, I'll be representing him.
All right, in that case, Mr. Spigner, please mute your screen until we are ready to address your case. All right, Mr. Howard, we are addressing Mr. Cedric Clark, who is at 4 South. He's been advised of his rights, and I understand this is going to be a non-negotiated plea. Would that be correct?
That is correct, Judge.
All right. Ms. Allen, could you please let me know what's the state's recommendation for the 5 charges?
Your Honor, the offer in this case, so these are concurrent offers on each of these counts. Count 1, criminal trespass and damage, is a 12-month probationary sentence to serve 90 days with credit for 16, balance probated. Stay away from 3255 MLK Junior Drive. No further contact with Clayton Stroud or Raheem Keshwani. Count 2 is the theft by shoplifting. It's concurrent, and the additional piece is an anti-theft course. Count 3 and 4 have no additional requirements. And count 5, the battery, is again concurrent with service of 90 days. Credit 15 or 16 he already has, also concurrent, balance probated, and stay away, no further contact. The additional piece is a 6-week anger management course.
A 6-week anger management course and
Anti-theft course.
and the
no further-
anti-theft class. Yeah. Okay. Got it.
Thank you.
Okay, Mr. Howard, it looks like it's additional jail time and went on probation, no contact, stay away, anti-theft class, and 6-week anger management program. Yes, sir.
Yes, Judge. And Mr. Clark is fine with those probationary requirements. It's just the additional jail time is what we would like the court to consider reducing to a 30-day sentence so that he would be released on probation. You know, he's willing to do the classes, he's willing to do the anger management as well as comply with everything else. We just don't believe it will be in his best interest or to remain at the Fulton County Jail, given everything that we know, for an additional 30 days, essentially, is what it would be. When we believe it would be better served for him to start the probationary requirements so that he can begin to try to move forward with his life and put this matter behind him. He's willing to take responsibility today for his actions, and we'd ask the court to issue a sentence of 30 days as opposed to 90 days with all the other requirements and conditions.
All right. I understand this was the incident at the BP gas station. Apparently, this was in violation of a prior trespass notice. Ms. Allen, do you have anything else to add?
Yes, Your Honor. So the defendant was previously criminally trespassed from the location. The clerk on the scene, who's one of the victims, Raheem Keshwani, reports that he's always there stealing. The individual that is the victim of the battery, Clayton Stroud, was someone who's employed at the location who helps clean up. And he was assaulted with a metal pipe by this defendant when he tried to prevent him from leaving with stolen items. Actually was struck in the face multiple times, excuse me, he was threatened. And the defendant was found after he'd fled the scene behind another store in possession of stolen items from the location, a bottle of wine and some other things. He refused commands, obstructed police, and had to be tased. He's got multiple convictions for batteries and theft since 2014. He's got an open, I believe, shoplifting and maybe a forgery case. So at this point, the state's position is that a period of time incarcerated is what's appropriate for continuous similar behavior against people who are trying to protect their property and do their job.
Mr. Howard, I'm going with the state's recommendation. Would you like to speak to your client, or is your client willing to proceed?
Mr. Clark, having heard the court's decision, do we need to talk further? Do you know what you want to do? Because we talked about it yesterday, but what are you still wanting to resolve it, or you want to do something different? You want to talk, do we need to talk further, or do you know what you want to do? I guess is what I'm asking.
They're not gonna come, I mean, she's not gonna help me out, like, she's not gonna go
Right.
over, she's not gonna do that.
Right, the jail time will be the 90 days, meaning you'd have about another 30 days like we discussed. So do you still want to resolve it or no?
Ain't gonna be no different.
So do you want to resolve the case today, or do you want to plead not guilty?
I mean, I want them to have a heart and let me go home. I had to go to the hospital, I had to get stitches. I'm the one that got struck in the face.
Okay.
All right, so this is a not guilty plea. Mr. Howard, would you like to submit?
No. Then we gonna just go along with what y'all got going on. I'm not gonna hold you up.
You're not holding me up. You've got a $7,000 bond. Yes, I do have a heart. I have a heart for you, and I have a heart for the alleged victims, and I have a heart for everyone. And based on everything I've heard, the state is recommending 90 days in jail. So I can recommend that you serve day for day. In other words, no 2 for 1, or I can recommend that the sheriff exercise their discretion and give you 2 for 1. There are a lot of options available to me, but then again, there are a lot of options available to you. You can either accept the recommendation by the prosecution, or you can exercise your constitutional right and have a trial. So do you need to speak to your attorney about your options?
Would you give me 2 for 1?
Do you need to speak with your attorney with your options?
Yes, ma'am. Yes, ma'am.
All right. Mr. Howard, I'm going to put you in a breakout with 4 South.
All right.
All right. Mr. McLean, who do you represent on the bench warrant matter?
Mr. Mason.
All right. Is Mr. Mason from the bench warrant case present?
Your Honor, my understanding was he was going to come to 901 Rice Street because G33 was not available. Last time he had problems getting onto Zoom.
All right. If you have his contact information, I would highly recommend you contact him, because I don't see him unless you see him in the gallery behind you.
Nobody's in that gallery, Your Honor.
That's also a possibility that if he checked in at the front desk at the Fulton County Jail, he may have already been surrendered. Unless that's him. Samsung?
That may be Mr. Mason, I'm not sure, but I'm not.
Samsung, you need to unmute. We don't know who you are. The gentleman in a car. We cannot hear you. You need to unmute your phone.
Mute, okay. Good morning, Your Honor. My name is Reynold Mason. I got an
Okay.
email from last night. I came here, been here since like 10:15.
Very
No one
good.
down.
You need
No.
to hold, you need to wait until we address your case.
Okay, I'm sorry. I was just
When
trying to
I-
let you know that. All right, I'll
When
wait.
I
Thank
call
you.
your name, okay, let's go ahead and mute Samsung and change his name to whatever was his first name. I just remember the last name, Reynold Mason.
Reynolds?
Thank you. All right. All right, Mr. Howard, what would we like to do with Mr. Mackey, please?
Judge, it's Mr. Clark.
Oh, Mr. Clark, excuse me.
Mr. Clark has indicated he does wish to resolve his case today, knowing that the court will sentence according to the state's recommendation.
That would be correct.
So that's
All
what he wants to do, Judge.
Okay. So we're resuming with the plea hearing of Cedric Clark, 23 CR 5937F. After conference with his attorney, the state is going to, the plea recommendation recommended by the state is what is going to be imposed if Mr. Clark enters a plea of guilty to the charges brought against him. 4 South, if we could unmute, please. Mr. Clark, please raise your right hand. Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes, ma'am.
Courtroom 2, please unmute your screen. Thank you. All right. Mr. Clark, have you consumed any medication or alcohol recently?
No, ma'am.
And have you understood the proceedings so far?
Yes, ma'am.
Are you satisfied with your attorney?
Yes, ma'am.
Are you entering this plea freely, willingly, and knowingly?
Yes, ma'am.
Are you being forced or induced to accept this plea by anyone?
No, ma'am.
If you decide to enter a guilty plea with regards to these 5 charges, you will have to give up your constitutional right to a trial. You will not come back to court or face a judge or a jury. You will not be able to challenge the evidence brought against you, whether it's by documents or witnesses. You will not be able to confront your accuser. You will not be able to present any defenses if you choose to do so. And you will not be able to have the state try to prove the original charges against you beyond a reasonable doubt. Are you prepared to give up these rights?
Yes, ma'am.
How do you plead to 1 count of criminal trespass causing damage to property at the BP gas station, theft by shoplifting, criminal trespass, possession and use of drug-related objects, and battery?
I plead guilty, Your Honor.
All right, your sentence is going to be concurrent. You are going to serve 12 months, 90 days in jail. I will allow the sheriff to give you the 2-for-1 ratio for time served at the jail. You'll be given credit for 16 days. If you have no other holds at the jail, then you will be released after serving the additional time. You will report to the probation office at 132 Mitchell Street in downtown Atlanta at the first available business day, which would be Monday, Tuesday, or Thursday. You must report before 3 p.m. While you will report to probation every month. You will start paying probation fees every month. While you're on probation, you will complete that was the anger management classes. Oh, yes, here it is. You will complete 6 weeks of anger management classes. You must enroll in those classes within 60 days of being released from jail. You will also complete an anti-theft class, and you must complete that class within 90 days of being released from jail. As I said, you will report to probation every month. You will also stay 200 yards away from the BP gas station at 3255 Martin Luther King Jr. Drive. If you are seen at the building, if you are seen at the parking lot, if you're seen on the sidewalk, or if you're seen anywhere in that store, you will be arrested and your probation will be revoked, where you will have to complete the rest of your jail time in prison, or your rest of your sentence in prison. You are also to have no contact with Rahim Keshwani and Mr. Clayton Stroud. You have to stay 200 yards away from them and not communicate with them in any way, form, or manner. You're not to consume any illegal drugs. You're not to consume any alcohol, and you're not to possess any weapons or firearms. That concludes your sentence. Thank you.
Thank you.
Next is, position number 16 through 19, Mr. Robinson.
All right, Mr. Robinson, okay. This would be Mr. McLean's client. Mr. McLean, if you could unmute, please.
Your Honor, Mr. Robinson's negotiated plea.
All right. Mr. Robinson, this is State versus Ronnie Christopher Robinson. And the cases in which we are addressing today begin with position 16, 20 CR 5540F, in which Mr. Robinson is accused of forgery in the 4th degree from April 27, 2019. I understand position number 16 has been null crossed. Would that be correct?
That is correct, Your Honor. In
All right.
conjunction with the pleas.
All right, so position 16 is null crossed. Position 17 is a bench warrant, which is 23 FTA 914, and this will be null crossed if the plea moves forward. Positions 18 is 23 FTA 915, and that's a bench warrant, and that will be null crossed if the plea moves forward, which leaves us with the last case, position 19, 20 CR 005562F, in which he's accused of forgery in the 4th degree from April 27, 2019. Mr. Robinson, you have a right to remain silent. Anything you say about the facts of your case, your statements can and will be used against you. You have a right to an attorney, and Mr. McLean will be representing you. For purposes of the plea, Mr. Robinson, please raise your right hand. Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes, ma'am.
Thank you. Mr. Pierre Thomas, what's the recommended sentence for position 19?
And Your Honor, before we move forward, I just want to correct something. Positions number 16 and 17 will be null crossed no matter what, as duplicitous to positions number 7, and duplicitous to positions number 18 and 19.
Understood. Thank you.
So the recommendation for position number 19, Your Honor, would be 12 months probation, 50 days to serve, credit for the 26 days that he's already served, with a stay away from AR Financial Services, which is located at 5015 Old National Highway, and the balance would be suspended on this charge.
All right, thank you. Mr. McLean?
Correct, Your Honor. That is the negotiated plea that we would like to offer to the court, and we ask the court to accept that. We stipulate to jurisdiction and factual basis and identification.
Mr. Robinson, please, of Forsyth, please unmute. And we can mute courtroom 2, please. Thank you. Mr. Robinson, have you consumed any medication or alcohol recently?
No, ma'am.
And have you understood the proceedings?
Yes, ma'am.
Are you satisfied with your attorney?
Yes, ma'am.
And has it been explained to you that if you enter a guilty plea to this charge of forgery in the 4th degree, that you will be giving up your right to have a trial in front of a judge or a jury to be able to confront your accuser and have the state try to prove the charge against you beyond a reasonable doubt?
Yes, ma'am.
Are you entering this plea freely, willingly, and knowingly?
Yes, ma'am.
How do you plead to one count of forgery in the 4th degree?
Guilty.
Your sentence is 12 months to serve 50 days, credit for time served 26 days, balance suspended. You're to stay away from 5015 Old National Highway, the business offices of AR Financial Services. Thank you. That concludes your sentence.
Okay.
And position number, position 18 is null crossed. Position 16 and 17 are null crossed as they are duplicates.
Position number 22 through 23, Lord.
Is Ms. McLeod on Zoom? No? Okay. 22 through 23, and that is Phelan Thor. Is that correct? Are you Mr. Phelan Thor?
Correct.
All right. This is case Position 22 is a bench warrant, 23 FTA 912. And 23 is the case of 20 CR 5992C, in which Mr. Thorpe was accused of battery family violence from December 11th, 2020. Mr. Thorpe, you have a right to remain silent. Anything you say in open court, your statements can and will be used against you. You have a right to an attorney, and representing you is Mr. Michael McLean. Mr. McLean, is this a negotiated plea? Please unmute, sir.
There we go. It is, Your Honor.
All right, Ms. Pierre Thomas, please, could you give us the recommendation?
Absolutely, Your Honor. The recommendation as it relates to Mr. Thorpe is 12 months to serve 44 days, credit for the 22 days that he's already served, with the balance probated, the special conditions being family violence intervention program completion, 40 hours of community service, a no further contact with Philip Thorpe, and he stay away from the location of 2014 Thomasville Drive, Atlanta, Georgia.
Mr. McLean, does your client accept these terms, and do you stipulate to the factual basis, venue, and ID?
He does.
Right. Mr. Thorpe, have you consumed any medication or alcohol recently?
No, Your Honor.
Oops, I lost you. There we go. And have you understood the proceedings so far?
Yes, Your Honor.
Have you, are you satisfied with your attorney?
Yes, Your Honor.
And is anyone forcing you or inducing you to take this plea today?
No, Your Honor.
If you decide to plead guilty to battery family violence, that would be a conviction on your record. Any subsequent offense for battery family violence will automatically be a felony charge. Has that been explained to you?
Yes, Your Honor.
And are you still willing to move forward with this plea freely and knowingly?
Say again.
Are you still willing to move forward with this plea freely, willingly, and knowingly?
Yes, Your Honor.
You would have to give up your right to a trial. You will not be able to come back to court to face a judge or a jury. You will not be able to confront your accuser. You will not be able to challenge the evidence and the witnesses brought before you. And you will not be able to have the state try to prove the charge against you beyond a reasonable doubt. Are you prepared to give up these rights?
Yes, Your Honor.
How do you plead to one count of battery family violence?
Guilty, Your Honor.
Your sentence is 12 months to serve 44 days, credit for time served 22 days. You'll be if you have no other holds, you'll be released and placed on probation. You will have to report to the probation office next Thursday, October 26th, before 3 p.m. While on probation, you must complete a 24-week domestic violence program, and you must enroll in those classes within 60 days of being released. You will also complete 40 hours of voluntary community service at any nonprofit agency, and that community service must be completed within the time allotted for probation. At all times, you are to have no contact with Philip Thorpe. You have to stay 200 yards away from Mr. Philip Thorpe and not communicate with him in any way, form, or manner. You're also to stay away from 2014 Thomasville Drive in Atlanta, Georgia. That completes your sentence. Thank you. The bench warrant will be null pros. That would be position 22, I think. Yeah.
Okay, the next person, is position number 20 and 21, Maurice Thompson.
This is State versus Mr. Maurice Darnell Thompson. Mr. Thompson, you have a right to remain silent. Anything you say in open court, your statements can and will be used against you. You have a right to an attorney, and representing you is Mr. Michael McLean. Mr. McLean, how is your client proceeding on positions 20 and 21?
This is a negotiated plea, Your Honor.
All right. Mr. Thompson, on position 20, your case number is 21 CR 7503Y, in which you are accused of criminal trespass and violations of certain rules at a bus or rail station, and from a June 6, 2021 incident. In position 21, that is a bench warrant, 23 FTA 913. The bench warrant will be null pros if we successfully accept your plea. Mr. Pierre Thomas, what's the plea offer?
The plea offer in this case is a time served plea offer, 19 days to serve on count 1, as well as a time served offer, 19 days to serve on count 2.
All right, and how much time has he already served?
I believe at this point he served 19 days.
All right. Mr. McLean, does your client agree to these terms, and do you stipulate to the factual basis, venue, and ID?
He does, and we do.
All right. Mr. Thompson, have you consumed any medication or alcohol? And have you understood the proceedings?
Yes.
Are you satisfied with your attorney?
Yes, ma'am.
And are you entering this plea freely, willingly, and knowingly?
I am.
I'm sorry?
Yes, ma'am. Yes, ma'am.
If you decide to enter a guilty plea to these charges, you will have to give up your constitutional right to a trial in front of a judge or jury, not to be able to confront your accuser, challenge the evidence brought against you, and have the state try to prove the original charges against you beyond a reasonable doubt. Are you prepared to give up these rights?
Yes.
How do you plead to 1 count of criminal trespass and 1 count of certain acts at a bus, rail, certain prohibited acts at a bus, rail, or station?
Yes.
Your sentence is 12 months to serve 19 days, credit for time served 19 days. Your your sentence for this particular case is concluded. The bench warrant will be null prost. Thank you. For South, do we have any other cases?
No, we don't. The only person we have remaining is the competence calendar person.
All right, we will address that very shortly. Please give us a moment. Mr. McLean, do you have any other cases remaining on the SAP calendar?
Let's see, I think that was it, Your Honor.
All right. And I have an add-on, Deneen Walker.
Well, Your Honor, we had a refusal to interview. I think we're going to have to evaluate that.
All right. The reset date, is that going to be a reset pending evaluation?
Yes, Your Honor, I'll speak to Mr. Howard about whether to go to a particular calendar or not.
All right, so I can reset it to 11 a.m. Competency calendar pending evaluation. And since an evaluation is going to be requested, we're going to reset it 5 weeks out.
Your Honor, let me ask Mr. Howard if he just needs to have a social worker exempt.
Yeah,
before we go that way.
Right, before we do that, Judge, and set it out that far, we need a chance to assess kind of what's going on. So I don't know that it'll be an eval, but she's been refusing. So we plan to go out. I'm going to try to go out this afternoon to see her. Deputy Milton indicated she would escort us up to the floor to see her since she's refusing to come out.
Reset would then be October
So just next week.
26th
Yes.
at 11 a.m. And if you deem an evaluation to be appropriate, please let Mr. Michael Jordan or Miss April Champion know, and the case will be taken off the calendar.
Yes. Okay.
All right, thank you.
Yes.
With regards to the SAP calendar, position 1 has been transferred to the DA's office. Position 2 was a plea. Position 3, Cedric Clark, was a plea. Position 4 was a plea. Position 5, Gresham, was a plea. Position 6, Gabriela Gutierrez.
And actually, Judge, if we could address that case when we do our competency breakout, I think that'll be best.
All right, please remind me to do so,
Yes.
okay?
Yes.
Position 7 is a waiver of arraignment and further notice for trial. Position 8 is a waiver of arraignment and further notice for trial. Position 9, same announcement, further notice for trial, waiver to be submitted. Position 10, Quadrico Nance is released. Position 11 is a not guilty plea. He was not brought to the jail, not brought for an appearance. And Mr. Howard, this is affecting positions 11, 12, 13, and 14.
Yes.
Are you filing a waiver of arraignment and in all these 4 cases?
Yeah, sure. We have filled it out and we're ready to file it.
Okay, so this will be waiver of arraignments and further notice for trial. Position 15 was Mr. Riley, represented by Maureen McLeod. I've not heard anything else since then. All right, reset to October 26. SAP calendar. Ms. McLeod would have to reach out to a client. Position 16 was null pros, 16 and 17 were null pros as duplicates. 18 was null pros pursuant to the plea, and position 19 is a plea. Position 20 is a plea, 21 is null pros. Position 22 is null pros, and position 23 is a plea. Position 20, 24, Leonard Watson. Leonard Watson, Mr. McLean?
Your Honor, that also would be a waiver of arraignment and waiver of presence as a not guilty, and we'll file that as well. We've already got it, and so I'll be feeding that into the scan shortly.
Thank you, Mr. McLean. Mr. Leonard Watson is further notice for trial pursuant to the waiver of arraignment. Position 26 is reset to the October 26, 11 a.m. competency calendar. And I'm sorry, that was position 25. 26 was a plea.
Your Honor, if I could just perfect the record on, looks like position 23, our office was in contact with the victim, Philip Thorpe. He's advised that he would not be on the Zoom at the time. He agreed with the plea, but if we could sound for him at this time, that'd be greatly appreciated.
Philip Thorpe, if you are on the Zoom, please unmute and start your video. All right, he's not. I'm going to address my bench warrant cases and then resume my competency calendar. Mr. Mason or Mr. Spigner, whoever starts the video first. All right, Mr. Spigner.
Yes.
All right, sir. Please remember that you have a right to remain silent. Anything you say in open court, your statements can and will be used against you. You have a right to an attorney, and if you cannot afford one, one will be appointed to represent you. I understand that Mr. Derek Howard will be representing you. This is case 23 CR 290Y. Oh, excuse me, correction. This is case 23 CR 3860J. Mr. Maurice Spigner was originally accused of simple battery family violence. He received a $3,500 surety bond on June 17, 2023. His case was scheduled before Judge Besson on August 28, 2023. It appears that he did not respond to the court summons, and a bench warrant has been issued for his arrest. Mr. Howard, how would you like to proceed?
Judge, in speaking with Mr. Spigner, he tells me that he did not receive notice of that court date. I did not see a return to sender on Odyssey, so I'm not sure about the status of that, but he indicates the address that he put on the notice that was, resetting the case to today is his proper address. And he tells me that he received a call on October the 4th from a court personnel indicating he had missed court, and that was the first inkling that he had missed court. And being notified of that, he came down to handle the matter. He is not someone who is in any way attempting to abscond or not show up to court or avoid prosecution. I forwarded an email that I received that he forwarded me from his pretrial officer, where he's been reporting monthly to pretrial, and he indicates his pretrial officer never indicated that he had any court dates or that he missed any court dates. And the email that I sent was after this court date. It was on September 20th, where the pretrial officer indicated that, hey, thanks for checking in. You don't have any court dates. And I tried to reach out to her and call her as well so that she could potentially join the Zoom if need be. But I did not get a response from her. But he indicates he has certainly not been trying to avoid this, and he's been checking in, every month as required to do through pretrial. And so it's just a situation where, according to him, he had no knowledge of the court date. And Judge, I don't know if he has any other failure to appears or anything of that nature, but I do believe this was not an intentional act. That it was just an unfortunate event where he was not aware and missed the court date. And so we'd ask the court to set aside that bench warrant pursuant to that.
Let me. All right, Judge Besson issued the warrant. It was $7,000 bond issued on September 1st, 2023. Okay. And the address we have is something called Jones Street.
Yes.
All right, Mr. Pierre Thomas, any response?
No response, Your Honor.
All right, I'll set aside the bench warrant. Mr. Spigner is required to come down to the clerk's office at J150 within the next 7 days. And I want him to put down his current mailing address, his phone number, and his email.
And actually, Judge, I think he did that, which prompted the hearing today. I did see a PDF file on showing the current address, showing the phone number and the email address. That's actually how I sent him the application. I got it from that document. So that was done recently. So that is in the clerk's office possession.
All right. I have a Gmail address. Is that correct?
Yes.
And the cell ends in 3244.
Is that let me see. Is that the number, Mr. Spigner? I'm not looking at the document.
It's 9889.
You do.
No. Yeah, that's right, Judge. The document.
Okay, they've got it the other way. I've got two phone numbers, one ending in 9889, one ending in 3244.
The 9889 is the number that this is the correct number.
Yes.
All right, that's listed as a home number, a landline.
No, 9889 is a cell number, Judge.
Okay, well, we can amend that. And the Jones Avenue is the correct address.
Yes.
Okay. All right, Mr. Spigner, then I'm going to set aside the bench warrant. Your attorney is going to submit a proposed order. And Mr. Howard, if you could please make sure the order gets to Miss April Champion so that the bench warrant may be set aside.
Yes, Judge.
Mr. Spigner, the bench warrant is still active until the court enters the order to be submitted by your attorney. Please be mindful that any changes in your address or contact information must be reported to the court. As you can see, if you fail to appear, things like this happen.
Yes, thank you.
Thank you. You're free to go. Mr. Mason? Reynold Mason? Have we lost Mr. Mason? I don't see him as a participant. Did he fall out of Zoom, Ms. Grace?
I'm not seeing him neither, Judge.
All right.
He
Mr.
was on
McLean?
earlier.
Yeah.
I'll call it.
All right, thank you. And Mr. McLean, we will resume with him once I complete the competency calendar. All right, so who needs to be in the Zoom with will be Mr. Howard, myself, Ms. Kasha. Is she still with us? Ms. Kia Burgess.
Yeah, Kasha is here in person, so yes, Kia Burgess, and I'm assuming Miss Helena Allen would need to be
Ms.
in.
Allen, is Mr. Pierre Thomas joining us as well?
Which case is this on, Your Honor?
This is the competency calendar. We have Holcomb and Tessan Yu.
I think it's me. Mr. Thomas, do you have any other information?
I don't have any other information. I'll just join for educational purposes.
Right. Thank you.
All right, as soon as Ms. Grace places us in the, or is it going to be Ms. Champion? I'm just waiting. Mr. McLean? Oops, we've lost courtroom 2. Do we have Mr. McLean?
Hey, Judge Law, McLean stepped out. I don't know if he left.
Okay.
Well, he's probably coming back, I guess. I don't know.
I doubt that he just left, Judge. He probably went to see if he could find Mr. Because I think Mr. Gentleman may have been in the parking lot at the jail, and he's probably going out to try to find Mr. The gentleman that's waiting, Raymond Reynolds.
Okay.
Mm.
Miss Allen, while we are waiting for Mr. Mason, have you reviewed that case?
Your Honor, the information I have is that this case was incident in January of last year. It was domestic violence battery.
No, I was just going to ask whether you reviewed it. I didn't want to engage in a narrative until Mr. McLean and Mr. Mason appear.
So it's on the bench warrant calendar. Yes, I've reviewed it to some degree.
Okay.
It's hard for me to tell, like the last position, Mr. Spigner, it looks like the notice for him for court was sent to the address that he gave in court.
All right, so we'll wait on Mr. Mason and Mr. McLean. We can pause on the live stream and the recording until, and Mr. Howard, could you text Mr. McLean if you have that ability right now from your laptop or email him?
Yeah, I'll see if try to figure out where he is.